Hello, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. Our fees are based on your income, so the less you make, the less you pay. Today, I want to be discussing a jury trial as opposed to a bench trial for criminal cases in Massachusetts. As a criminal defendant in Massachusetts, you have the absolute right to a jury trial. That means you can take your case before a jury of your peers and try your case and have them decide the outcome of the case. Now, you may want a jury trial or you may want to opt for what's called a bench trial. A bench trial is where a judge sits alone without a jury, and the judge is the fact finder. So the judge will make the decision guilty or not guilty. With a jury trial in the district courts in Massachusetts, there are six people that are chosen that will ultimately make that decision. There will be seven people that will be chosen for the jury. One person is an alternate. So ultimately, six persons will make the decision guilty or not guilty. Those people will be chosen from the community, so they have to be in the county where your case is being heard. Um, we would help choose those jurors, we and the prosecution. What happens is basically there's a group of people that get roped into jury duty on any particular day. They get assigned to your court, and if you have a jury trial, they at some point will be brought into the courtroom. That's the veneer, the jury veneer. That's the entire group that's in the jury pool. Um, One by one, they'll be brought up before a judge, and would be usually happens at sidebar, and the prosecution and we would help decide whether or not we want that person on the jury. What happens is they fill out a one-page questionnaire, some biographical information. So it has their name, their spouse's name if they have one, where they work, where the spouse works, and importantly, do they have any ties to law enforcement? Do they have any? Are they in law enforcement? Do they have family members who are police officers or correctional officers or the like? And have they had any dealings with the court system? Have they been convicted of a crime, charged with a crime, victim of a crime? Or even if have they had court something from the civil side? Have they had a restraining order that they needed to get, or whatever it might be? For our purposes, usually the most important thing is, do they have connections with law enforcement? And secondly, have they ever been charged or convicted of a crime? So what happens is we have this information. The judge will also ask the jury a number of questions, what they call voir dire. Those are just questions that they ask of the jury, and they're looking to see if they have any ties to law enforcement. Is there any reason why they think that they can't serve, and so forth. Um, and especially on cases involving OUIs, operating under the influence, drunk driving, in other words. We also want to find out, do they contribute or are they members of any groups that have as their base, they address alcohol driving issues, such as Mothers Against Drunk Driving, Students Against Drunk Driving, and so forth. Have they or their relatives ever been involved in a car accident where alcohol was involved? That could be very important to know if you have an OUI trial. So we're always looking for, we always usually want to bump out anyone who has ties to law enforcement. Generally, the prosecution wants to keep them in. So what happens is each side gets two peremptory challenges. That means they can knock out two jurors basically for any reason without having to state a reason. So we could just say, no, I don't want juror number 24, and juror number 24 will be gone. But you only have two of those. We also have an unlimited amount of for cause challenges. So that means if there is somebody that has ties to law enforcement, or if there's some reason we believe that they cannot be fair to us and render a fair verdict, we can ask the judge. We can tell the judge we have concerns, lay out the argument. The judge will decide yes or no that the judge believes they can be fair and impartial. If the judge feels that they cannot be fair and impartial, they will be excused. That doesn't count as one of our peremptory challenges. So at some point, the jury gets picked. Like I say, there are seven that will listen to the case. At the end of the case, one of those persons is chosen as an alternate and doesn't get to deliberate, does not get to make the final decision. The reason why you have an alternate is that during the course of the trial, if one of the jurors gets ill or has a family issue or for some reason cannot complete the trial, instead of having to start all over, that person is excused, and now we're down to six. So there are still six people that can make that decision. My own personal thought is I almost always want to go with a jury trial. And the reason is you have six people that are making your decisions. Obviously, it's an extremely important decision in your life, guilty or not guilty of a crime. We have six persons that to try to um, come around to our side. So in a jury case, the jury has to be unanimous in their verdict, all guilty or all not guilty. If even one person is a holdout saying not guilty, and the other five are convinced of your guilt, if that one person still says not guilty, it's at least a hung jury, and that's a mistrial. So the Commonwealth can then, retry, refile a new complaint and go through the process, and ultimately you can be tried again for that. But it's at least a win, because with a judge sitting alone, it's only one person making that decision. So if you don't convince that one person of your non-guilt, there's no other person that can be relied upon to try to convince that person. So we have a 1 in 6 chance with a jury. We have a 1 in 1 chance. So it's 50-50 with a judge sitting alone. There are certain cases where if the facts of the case, or if the case really turns on a particular specific issue of law that the judge would have more experience with and more knowledge of, then we might consider going with a bench trial. A lot of times we schedule bench trials, but those are cases where we're expecting a victim not to show up or not testify against you or so forth. So oftentimes bench trials are used to push cases forward, and if the prosecution can't go forward with a case on that day, we ask for a dismissal. But for the most part, jury trials, in my opinion, in criminal cases are the way to go, because you get the six different people, and they can rely on their experience, and you have a choice. You help choose who it is. The judge is the judge. You have no choice. We can't go judge shopping in situations like that. So for those reasons, I usually always recommend a jury trial. So, as I say, at Afford Law, we do practice criminal and family law throughout Massachusetts. Our fees are based on a sliding scale, based on your income. So the less money that you earn during the year, so your annual income, the less you have to pay for our services. We're trying to give a voice in the courtroom to the hardworking men and women of Massachusetts. Please feel free to visit us at affordlaw.org. And while you're there, feel free to book a free virtual appointment with me. I'd be happy to answer any questions you might have about any criminal or family law questions in Massachusetts. Because at Afford Law, we're making justice affordable.